Jonathan Lee Riches Investigates. I am covering the Moscow, Idaho Bryan Kohberger case. Bryan Kohberger just indicted by a grand jury in Idaho. He has a arraignment Monday morning, 9 a.m. And a lot of people are wondering out there if Bryan Kohberger will ask for a bond hearing, because normally people that get arraigned or go to court for initial charges, they have the right to ask for bond. And people are wondering because this is a new indictment. This is something new. So going through that process the second time, because he's already went through it back in January when he had his initial appearance, which he had his bond denied. But this is a new indictment. You're going in. So people are wondering, and people have been sending me a message, JLR, does Bryan Kohberger get a bond hearing? And it made me do the research. I want to show you the actual process of what's going down with Bryan Kohberger on Monday. This is the process. This is how it works in Idaho. So check this out. So it looks like Bryan Kohberger's situation falls under Idaho Criminal Rule 10, arraignment on indictment or information. In general, after an indictment or information has been filed with the district court, the defendant must be arraigned on it by the court. The defendant must appear in person at the arraignment. The arraignment must be within 30 days after the filing of the information. If an indictment has been filed, the arraignment must take place within 30 days of service of the summons if the summons has been issued, within 30 days of the defendant's initial appearance in the county issuing the indictment if a warrant has been issued following the indictment, and if the defendant is not in custody in the county in which the indictment is filed, or within 30 days of the filing of the indictment in all the cases. So looks like the prosecution has 30 days, or it looks like 30 days before Bryan Kohberger has up to 30 days to arraign Bryan Kohberger and anyone that gets an indictment. This is for anyone. Right to counsel. If a defendant appears for arraignment without counsel before being arraigned, the defendant must be informed by the court that the defendant has the right to have counsel either of defendant's own selection or, if indigent, by court appointed. And obviously, Bryan Kohberger is indigent. He has Ann Taylor already representing him. The defendant must be asked if the defendant desires counsel and if the defendant is able to provide his own counsel. Now, maybe they do this whole process over again. But I think since Ann Taylor is already appointed to him, because, this is like arrest and initial arraignment on the normal process and then indictment, I think, she will stay on the case. If the defendant desires counsel and is found to be indigent as defined in Idaho Code 19854, the court must appoint counsel to represent the defendant. No proceedings may take place before the appointment of counsel or until the defendant has a reasonable period of time to obtain counsel unless the defendant waives the right to counsel. Arraignment. Arraignment must be conducted in open court and consist of reading the indictment or information to the defendant or stating to the defendant that the substance of the charge and requiring the defendant to plead to it. The defendant may waive the reading of the indictment or information. So he can be there, Kohberger, but he could waive it, waive the reading of it. The defendant must be giving a copy of the indictment or information before the defendant is required to plead. The defendant must be informed that if the name that appears on the indictment or information is not the defendant's true name, the defendant must then state defendant's true name or be proceeded against by the name in the indictment or information. If on the arraignment the defendant requires time to enter a plea, the defendant must be allowed a reasonable time, not less than 1 day. So it looks like, right there within the day, he has to, decide, right there. He has to, decide whether he, reasonable time to enter a plea, it looks like, in which to answer the indictment or information. That's interesting there. Method of securing defendant's appearance. When the defendant's appearance is necessary and the defendant is in custody, the court may direct the officer who has custody of the defendant to bring the defendant to court. If the defendant is at liberty on defendant's own reconnaissance or on bail pursuant to court order issued in the same criminal action, the prosecuting attorney must, on at least 3 days' notice to the defendant and the defendant's attorney, notify the defendant and defendant's attorney that an information or indictment has been filed against the defendant and the time and place set for arraignment. So, It looks like Bryan Kohberger was indicted on Wednesday, maybe Tuesday. So 3 days, if it was Wednesday, that he got recognized, they showed him the indictment. I think it was Wednesday morning when they officially let him know. So they got 3 days. There were 3 business days. So Thursday, Friday, Monday. You follow what I mean? Notice must be given to the defendant either in person or by mail at the defendant's last address. If the defendant who is at liberty on defendant's own recognizance or on bail pursuant to previous court order to issue in the same criminal action does not appear to be arraigned, the court, in addition to the forfeiture of undertaking or bail, may issue a bench warrant for defendant's arrest. That doesn't apply to Bryan Kohberger because he's already in custody. So that is the process here. That is the process of what's going on here. And pretty much see. If you're interested in knowing more about how this works, Idaho Criminal Rule 10C, the arraignment process. Let me know what you think. So it looks like, according to the court rules that I just showed you, that it has nothing to do with a bond hearing. It's just, there's a process there, and they'll just read him, his charges. Now he can wait a day, believe it or not. If you notice what I showed you, he could say, I need more time to prepare, and I think he has a day extra or whatnot. He can't avoid it long term, but it doesn't look like he can ask for bond there. But though he might be able to raise a new bond issue, because it looks like the standing that no bond he had before in his initial appearance back in January, that's still standing. So it's not like you can. But at any time, I believe through the process, his lawyers could ask for bond. Should Bryan Kohberger get bond? Do you think his lawyers would be fools to ask for bond, knowing that he won't get the bond? I don't think anyone in this country that is accused of murdering 4 innocent people and burglary would be entitled to bond. It's not like 4-time murders are on the streets right now on bond on pending charges, though nothing surprises me in this world when people do things and how the process works. But that kind of gives you an understanding of what's most likely going to go down Monday morning, 9 a.m., Latah County District Court in front of Judge John Judge. We're going to hear that term a lot in the Bryan Kohberger case. Judge. So remember that name. And also, if Bryan Kohberger did get a bond, I only got $20 in my hand. How much do you think that bond would be? How much do you think that bond would be? And I think in some states, and I believe in Texas, no matter what you do, they still have to, give you a number bond. There's a few states, I believe. So, for instance, if Bryan Kohberger did this in Texas, and they have to give you at least a number of bond, they might have said, bond, $1 trillion. Bryan Kohberger, I'm setting your bond at $10 trillion. I mean, I think that happened with the Robert Durst case in Texas at one point. I think the judge gave him a $1 billion, bond. Of course, his attorneys appeal it and say it's unreasonable, but Bryan Kohberger's not getting out. He's not going to get bond. He doesn't even probably have he doesn't have $20 to his name. No way they would let him out. That would just be a publicity nightmare for the entire state. Though I do think his lawyers can actually raise the bond issue again at any time. But if they do that, we know that Ann Taylor and his defense team would not be serious in handling this case and just filing frivolous motions just to try to delay the process. You would think that Bryan Kohberger would not file a bond, knowing that he's not going to get out, and try to get this process over with as quick as possible, because like we heard out in Pennsylvania from the public defender's office, LaBar, Bryan Kohberger wants to get to Idaho to exonerate himself as fast as possible in that sense, right? As quick as possible. Well, it doesn't look like he's trying to do that as quick as possible. It looks like he's trying to delay the process, probably to get a technicality in the case so it can get thrown out by, just waiting to see if the prosecution messes up, whatever like that. I think the prosecution has been doing a phenomenal job. I think the indictment was an ingenious move. I think Bryan Kohberger waiving his right to a speedy preliminary hearing and trial ultimately hurt him in the, because now the preliminary hearing's not happened. Prosecution doesn't have to reveal their cards. It goes right to the district court. And the prosecution, having the DP over Bryan Kohberger is extreme leverage. I think Bryan Kohberger, after this arraignment on this case, we might never see him. Well, we might see him in court again if he pleads guilty, but there might not even be a trial. People assume that there's going to be a trial with Bryan Kohberger. He might end up just pleading guilty, and none of the victims and none of the evidence, even the officers, might not have to testify at all. It's a very strong possibility, which hurts all of us if there's a gag order and we still don't know what's going on. Subscribe to my channel, hit the notification button. Will Bryan Kohberger get a bond hearing? Does he deserve bond? Obviously, the answer is no, but I want to know your thoughts, so I'm going to read the comments. We'll talk soon. Stay tuned.